Good afternoon, everyone. I'm here in Syracuse, New York. My partner, Allison Matthews, is in Garden City, and we're happy to join you for our first municipality seminar or webinar for this 2023 year. Wanted to talk a little bit about Section 71 and 73 of the New York Civil Service Law. In my experience, and Allison may feel the same way or differently, but in my experience, this is one of the most complicated and misunderstood and often misapplied statutory sets of statutory provisions in New York. It's complicated for a number of reasons, which we'll talk through, but I think one of the main reasons it's complicated is because when you have someone who's out on some type of leave for disability, there's very often it's the case that multiple statutory provisions and coverages are in play, as well as collective bargaining agreement provisions for unionized employees. So it's a tricky area. My sense also has been that very often employers are not aware of the provisions and end up leaving employees out on leave for indeterminate or too long a period. And so really what we want to do with today's webinar is to give you the nuts and bolts of Section 71 and 73, help you understand how they apply to the rights that both an employer has, as well as the rights that they bestow on employees. There has been recent litigation and case law that we want to report on in this area. So we want to just cover that as well. And then offer our experience, kind of our input on what we've seen that has been problematic at times, as well as give you some advice on ways to limit exposure to litigation, having to go through lengthy court cases in these areas. So, if you could go to the next slide, Kathy, please. So just in terms of the landscape here, we're talking about two statutory provisions, 71 and 73. 71 applies to workers' comp or occupational injuries or diseases, right? And that really does apply to that area. There's a separate statutory provision, which is 73, and that applies to non-occupational injuries or diseases. So they're two very often get confused by people because they're very close in the statute books, but 71 really does apply to comp or occupational related injuries, and 73, as I said, to non-work related injuries. They really do talk about, I think when you talk about these areas, there are really three buckets that you're talking about for 71 and 73. They talk about what is the leave of absence which must apply for employees who become disabled. Number two, second bucket is what is the process or what are employers' rights that may apply with respect to terminating employees who have become disabled and are out on leave. And then three, there's a whole reinstatement process and procedure that applies for people who have been removed from service due to their disability. And so we want to make sure we cover those things as well. Next slide, please, Kathy. So what this is all about is trying to help employers and employees and strike a balance between those two, the employer and the employee, because the employer obviously has an obligation to meet the public need and provide services to the villages or cities or community colleges, whatever it is, through employees who are employed. And so when someone becomes disabled and is unable to perform the duties of his or her position, obviously the work still needs to go on. And so there's the need to fill the position for the employer, as well as balance that against the need for the employee to get better and resume his or her work at the appropriate time. We all know about Section 75. 75 is the disciplinary procedure that applies for certain employees in New York who may be subject to misconduct allegations or have become incompetent in terms of how they perform their jobs. So this is a different process that we use where that the 75 process really isn't in play. There's been no misconduct. This is something that's occurred through no fault of the employee. But we're always thinking about 75 too, because there may be situations where there's some overlap in a disciplinary situation, as well as some form of leave that may be applicable as well. Next slide. And this is, you know, one of the landmark cases, citing back to a 1994 case, really, as I mentioned, trying to strike a balance between the state interest in having an efficient civil service workforce and provide the employee who has a property interest or due process rights with respect to his or her employment before being removed as a result of his or her inability to perform the job. So these procedures are in place, and we want to give you some basics on how they apply. And Allison's going to now dive into a little bit more depth on what 71 and 73 provide. Allison?
Thanks, Colin. So we're going to skip ahead to slide 8. So this is providing an overview of 71. As Colin mentioned, this is the statute governing employees with work-related injuries. They do not have to be actually receiving workers' compensation for this to kick in. It's really about an injury that's counted as a workplace injury as defined by workers' comp, but you don't necessarily have to be receiving the benefits. And what it does is gives the employee up to a year leave of absence, time to potentially recover from that disability. And if they don't, the employer is allowed to separate them. And then the employee can potentially come back there's a built-in reinstatement procedure after someone has been terminated. So if we go to the next slide, we'll really get into the details here. And as Colin indicated, it is a complicated area because the statute is almost like a declaration of this right. And there's all sorts of details that come into play when you're actually working to implement it that just aren't in the statute. And it's developed in case law with disability-related case law, collective bargaining, and the like that really makes it a complicated area. So for this statute, this is the work-related one. The leave of absence is 1 cumulative year, unless it's an assault that takes place in the workplace, and then it's 2 cumulative years. So what that really means is in the way that it operates is it's tied to the actual injury. So if you are a cumulative year, that means if you go out and you come back and you go out again, all that time is going to add up together so long as it's related to the same injury. And we're going to talk about ways to protect yourselves to make sure all that is documented and you can continue to count that time. So it's counted on a day-by-day basis. It can include non-work days, and we really want to get to that 365 mark. So you need someone who's going to make sure they're watching the calendar carefully when the employee is coming back so we don't lose track of that time. And that gives the employee notice too, so they know how much time is left. So if they're really actively trying to recover, which isn't always the case, but if they are, they're really working towards it and they understand that if they don't get back by day 366, they may end up being out of a job. Okay, we go to the next slide. We talk about the reinstatement procedures. So once we get to that 366th day, employers have the option to terminate. They don't have to. There's a downside to that because if you don't have a consistent practice and you don't have a procedure in place, then you end up with like this optional exercise of discretion that can make it hard for you when you want to actually come and negotiate a procedure. And we'll talk about some of the strategies that come into play with negotiating procedures. But you want to make sure you terminate when you can at the same time for everyone. That avoids any differing treatment claims and it keeps your practice consistent across the board for everyone. Now, it's not ultimatum necessarily for the employee because once they are at the point when it's 1 year from when they've recovered, they have the right to go to civil service and say, hey, I'm all better. I want to come back. And if the medical examination says that, yes, they are able to come back, as long as there's a position that's vacant and the employer wants to fill it, they have the right to come to that position. If there's no vacancy or the employer is not going to fill that vacancy, then the employee goes on a preferred eligible list for 4 years. So there's not an imposition here that the employer must fill it. It's like any other preferred eligible list. It sits out there for the employer to use. We just have to take preference to those who are on that list, including someone who's come back from an injury. And it's the key here too, is not 1 year from termination, it's 1 year from the termination of the disability. So you have to kind of keep an eye on the clock. You're not necessarily free and clear 1 year from the termination date. It may continue on for quite a period of time. So if we go to our next slide here, this is one of the first areas where we find some interplay between Section 71 and other areas of the law. And one is a Family Medical Leave Act. So Family Medical Leave gives employees the right to be able to be absent from work and have that protected leave and maintain their health insurance for up to 12 work weeks in a 12-month period. Ideally, you want to start a practice where you're running FMLA at the same time as this 1 year leave of absence that Section 71 provides, because if you don't, a 1 year leave of absence could turn into 15 months. But this is one of the things to keep in mind here. So we want to make sure that when you put someone out on 71, they're getting that same leave of absence. They're getting the FMLA paperwork. We're running it concurrently, and we're looking at that 365-day leave at the same time. So no one's getting 15 months here, but that practice needs to remain in place. Otherwise, you're going to end up with a longer period of time. All right, so now we're going to look at Section 73. And this one is for non-related work injuries. So this one is a little bit different because we're talking about non-occupational injuries and diseases. And in my experience, this one comes up less frequently than Section 71. So for this one, it's a continuous period of absence, meaning it goes from day 1 to day 365 without any breaks when someone comes back to work. And that can be pretty difficult to meet because employees can take advantage of that by coming back for a period of time. And then if they go out again, we have to start the clock all over again. But the procedures, other than those two distinctions, it's essentially very similar to Section 71. Other than the one continuous year over the one cumulative year. But here, there's nothing about an assault that takes place outside of work that's going to trigger getting 2 years instead of just the one.
And Allison, if I could just jump in there
Sure.
with a question on this too, or maybe a comment, but in your experience, what advice would you give to employers who have an employee out on 73, in the non-occupational injury, in terms of that issue of coming back for a day or two, or some period of time, and then having the period start all over again? Any thoughts on that?
Sure. So I think in this one, even though it's not on this slide, FMLA does come into play here as well. So if someone goes out, it's still a serious health condition, whether it's work-related or not. So I always want to make sure that employers check the box on the forms that the employee has to be certified by a healthcare provider to be able to come back to work. If there are any sort of rights to a fitness for duty examination that come into play, I want that. I want doctor's notes that are clear, concise, give me the information to let me know that someone is going to be able to come back to work, that they're safe to do so. They're not going to hurt themselves or someone else by coming back to work. And that avoids someone just coming back to work solely for the purpose of restarting the clock. So try and put those gates up to make sure someone actually is able to come back to work, and that you have good paper trail to show that that's the case, because you don't want to end up where you let someone back and then you end up with a lawsuit because someone got hurt on the job and you really shouldn't have let them back early.
Yeah, I think that's great advice. And one other thing in addition to that is, I've had situations where, the working foreman or the supervisor on the job has no idea, and all of a sudden Colin shows up and restarts the clock. So it is important, I think, to communicate that to the appropriate workforce managers that, the person is not to be coming back to work until cleared by the village clerk or whoever it is.
Definitely.
Person.
And to keep that conversation within a small group of people, because we are talking about medical information. So not everyone is necessarily going to know, but sometimes what you see happening is the employee has a closer relationship with the supervisor. There's a conversation, and then the person that's actually supposed to make the decision about them coming back has a different take on it. And you end up with a little bit of a mess that you have to get through. So
Yeah.
any conversations about coming back to work, you should make sure to tell the supervisors that's got to come from the central administration or village hall, town hall, whatever it is, so that we're all talking the same conversation and it's not going in multiple directions.
Yep, I agree.
So in terms of being able to come back to work, so let's go to slide 14. This is a case illustrating the need to pass that exam. So it's the same rule. You get the right to come back to work. It's 1 year from when you recover from that injury or that illness, but you got to pass the test. So this case is showing that even though this person went out for a physical injury and was terminated for a physical injury, she ended up failing the psychological evaluation. So this to me makes a lot of sense. It makes sense to me why it got to the third department, but it also makes sense to me why it ends up being ruled the way it is. Because just because I terminated you for one injury doesn't mean we get to ignore all these other things that make you unfit for duty. You have to be 100% fit for duty and be able to come back to work. Again, it's a safety issue here. And we are allowed to deny reinstatement if someone is either physically or mentally unfit. It doesn't matter what the basis was for the original termination. All right, so this next one here is about having people come back to work. So this is yet another layer to this, this 71 and also with 73. This case happens to come out of section 73. So oftentimes employees will have indications from medical doctors that they can come back to work, but there's all sorts of restrictions that are put in place. The ability to allow an employee to work light duty is a managerial prerogative unless you've given it away through the course of collective bargaining. And it's not a bad thing necessarily that you give it away, but you've opened the door to letting someone come back in on light duty if you have that position available. On top of that, you do have an obligation to interact with employees and engage in that dialogue about what their restrictions are and whether they can come back to work, can they come back with an accommodation or not. But in this one, we have someone who was refused reinstatement because they were unfit for duty because they couldn't perform an essential function. And there is no obligation to accommodate someone if they can't perform the essential function, even with a reasonable accommodation. So in this case, we get to the 11th month mark where the employee's been out, they're about to be terminated, they're trying to come back, but they can't perform that essential function. And there really is no way to accommodate, I can't work overtime. So in that case, the employer was free to continue with the termination, and that was ultimately upheld by a court. Now, essential functions, another area here, we're getting to a lot of layers with these two statutes. Sometimes you have your local civil service department will have the job descriptions and will actually put little stars next to the essential functions. If they don't do that, or they don't have some sort of record that does that, you want to make sure you're consistent with it so that everyone is being treated the same way. So if working overtime is an essential function, it's got to be documented somewhere where you can point to it. You know that the employees are aware of this and you are implementing it the same for everyone. That again avoids someone coming around again and saying, hey, you discriminate against me on the basis of my disability because you let this person come back even though they couldn't work overtime and you said no to me. So we're looking at really keeping everything consistent in these cases because you are terminating someone on the basis of the disability, but this statute allows you to do so, but you need to exercise some caution when you exercise that right. So our chart here is just showing the similarities and the differences between the two statutes. On the left side of your screen, we're talking about the occupational injuries with the 1 cumulative year absences, the extra year if it's an assault. The procedure for terminating is pretty much the same. It's just a matter of how you count the time. The procedure for reinstatement is identical. And on the right side of the screen, we're talking about the non-work related ones. It's a continuous consecutive 1 year period. There's no bonus for an assault outside of work. The clock is different, so the termination procedure is a little bit different, but the reinstatement is exactly the same. So I think now we're turning to employer and employee rights. We're going back to Colin, and he's going to go over the way these statutes, even though it's sort of that overarching, hey, you get this leave of absence, when you dig into the actual wording of the statutes, you can start to pick out the rights that run to the employer and then the rights that run to the employee.
Great, thanks, Allison. Kathy, if you can go to the next slide. Yeah, so when we're talking about the employee rights in this area, there are really three pieces to the employee rights. One clearly is the leave of absence. Second, how the right to reinstatement and how that process is going to work. And then finally, how due process applies to this whole procedure. So I want to talk about those things in a little more detail. Next slide, please. So as we've said, this is pretty clear. I think it's pretty straightforward. If you're dealing with a work-related incident, you've got that one cumulative year. If you're dealing with non-work, it's the one continuous year. Those are the main things to make sure you keep in mind. Don't forget, although I've not seen this in my practice, but in a situation where someone has been permanently disabled, meaning there has been an indication from a medical provider that the person is never going to be able to return to his or her job, you don't have to go through this process. There's still some due process that I think we want to make sure we ensure, but there's no right to the full year leave of absence. So in that circumstance, you can move more quickly. Next slide, please. So reinstatement. This is one of the procedural areas you want to keep a close eye on. So when the individual feels that he or she is able to return to work, as Allison said, it must be within 1 year of the termination of the disability, which again can be farther out than the termination of employment as well. But I think one of the key things here is that the application must be made to the relevant civil service department or municipal commission. So I've had situations where the conversation begins with, say, the village by the employee, and the village is really subject to the county civil service procedure. And in that circumstance, it's important that the employee be advised that the application really needs to go to the personnel department, let's say at Onondaga County, if you're a municipality within the county. So that requires, and this can be a little bit tricky because you're now working with a separate set of officials. And so the better relationship you have with your county personnel department, if that's the Civil Service Commission, the easier this process can go. The trickier it can be if you don't have a great relationship with the governing Civil Service Commission. So anyway, that's where the application goes, and the process will be taken on by that Civil Service Commission. Now, I've also had arguments about who has to pay for the examination, and I see Allison smiling, so maybe she's had the same experience here, and I'll let her comment on it. But let me put it this way: in my experience, it has been a discussion between the county and the village, for example, about who is going to actually pay for the medical examination. In my opinion, and I have counties as clients as well, it seems to me the default rule would be that the county would be required to pay for the medical examination. And these are not inexpensive examinations, I should say, I should add as well. But I've had both entities take responsibility over the cost for the examination. Allison, do you want to weigh in on that too?
I agree with that. I've had an interesting experience when it came to, which we're not talking about today, but Civil Service Law Section 72, which is an even more remote type law that doesn't come into play that often, where the county punted to the village and said, this is your responsibility, not only to take care of the examination, but also to find the doctor. So I think it depends on how experienced the Civil Service Department is with administering these two statutes.
Right. Yeah, I agree. So the reinstatement right. So once they apply, once the medical examination is conducted and paid for, and the medical examination indicates, let's say, for example, it indicates that the individual is ready to return to work, has been cleared by the medical examiner, the person can return to that former position, of course, only if it's vacant. So we're not talking about bumping people. And I've had arguments from some, mostly unions, about that issue. It's simply a vacant position. if the former position, if it's vacant. Very often, in my experience, it's not vacant because the person has been gone for a while, and there's obviously a need by the municipality to get the work done. There can be a return to a vacancy in a similar position or a position lower grade, or a vacant position for which the employee was eligible for transfer. Now, overarching all of this, the employer can have an opinion that any vacancy that it has, it's not needed to be filled right now based on our workload. Now, that has to be a legitimate, defensible position. Because where we're dealing with disabled individuals who may have disabilities or formerly had disabilities, we want to be on solid ground if we're saying that the workload doesn't warrant filling of the vacancy. So, for example, if you've been filling positions over and over again over the past few months, it would be difficult to defend the decision that at this point, maybe we don't need to fill it. But you do have the ability to say, in this circumstance, we're not going to be filling this vacancy, in which point the person goes on a preferred list if a vacancy arises over the next 4 years.
Can I just add here on the medical examination, even though this is on the employee rights slide, what I like about this from the employer perspective is the decision about whether someone is fit, you have some cover there. So you have a civil service department that's overseeing this, not just for one municipality, but for all the municipalities in their jurisdiction. And they are the ones making that ultimate decision whether the employee can come back. If you are on a county side or the city side and you're the one administering these exams, make sure you're picking the appropriate doctors to conduct them. You don't want to have necessarily an internist doing a psychological evaluation if it's someone with some sort of a mental disability, and just make sure that you have that cover in place too, so that you're doing this in a very objective manner.
Yes, absolutely. Next slide, please, Kathy. So this is probably where I see the biggest mix-ups or misses from employers. You've got a situation where the person has been out in excess of a year and they send a termination notice. Under case law, it's very clear that individuals who are on leaves of absences under 71 or 73, they have right to certain due process. This is not overly burdensome, but it's very important that before we move to terminate, we do certain procedural steps. So what I typically do is to send out a notice, a pre-termination notice, along the lines of, Colin, you've been out since, for over 1 year. I've made the preliminary decision that you're going to be terminated effective X date. However, we have scheduled a meeting for you to appear if you would like to present evidence why you should not be terminated as a result of your 1 year absence or excess of 1 year absence. You must, submit a letter to us providing the reasons why you want you are requesting this meeting and what your basis is for saying that you haven't been out in excess of 1 year. So that all goes out, and that begins to establish the due process that's necessary. So then the person doesn't respond very often because they've given up on the position, or if they do respond, they say they don't want a meeting, or if they do respond and they want the meeting, you have the meeting. And all you need to do is listen to the person and hear what they have to say, come back, have a meeting, and decide internally what you're going to do. It's most likely there's not going to be anything that you learn in that meeting, that due process meeting, that's going to change your mind. But it's very important that you go through this process prior to just, issuing the termination notice. That would be subject to challenge, and there's sufficient case law on those points as well. There's also a very confusing set of regulations, they're very burdensome, I would say. And very often I've seen a situation where unions have said, you're not following this process set forth in the New York State regulations. And it's now settled, as we'll get to in a little bit, but there's been some divergent case law applying these regulations, which only apply to state employees in the context of municipal employees, village, town, county employees, et cetera. They don't apply to the process. They only apply if you're employing a state employee. So they're much more burdensome. They've got time requirements. And so just be clear, those don't apply, but you still have an obligation to provide some due process prior to the ultimate decision to terminate.
On this last one too, double check your local civil service rules too. So for example, Suffolk County requires that you put in the notification letter to the employee that they might be terminated, that's anticipated that they're going to be terminated, that they have the right to request a post-termination hearing. And it says that has to go in the letter. So make sure you cover yourselves and look at those rules to make sure that all those notifications go into the documents that you send to the employee.
Perfect. Yes, great advice. Next slide, please. So this is to my point, right? This is not an overly burdensome process. If you're thinking about, due process hearings, many of you may be thinking of a Section 75 hearing, which requires a stenographer and a transcript and, disciplinary charges to be issued. And there's a whole number of steps that you need to go through. That's not what we're talking about here. Ultimately, I think it's probably, a good idea. We'll get into negotiating the policy, but if you have an internal process policy document that you use in this case of how you're going to work through, the issuing of the notice for the issuing of the leave of absence, then the pre-termination notice, the termination notice, and any post-termination that might apply. All is in your internal documentation, and you just follow that along. So you just need to basically give the opportunity for the employee to be heard, explain his or her reasons for why she shouldn't be, or he or she shouldn't be terminated, and then finally, get back to the employee after that meeting. All right, next slide. So, the employer rights are obviously to be able to terminate the employee and to reinstate the employee if he or she is deemed appropriate to do so. Next slide. So obviously, your right as an employer is to be very clear that the leave of absence is not indefinite and that it is going to end at the 1-year mark. Now, one of the things that I think is very helpful to do, and this can be part of your policy document as well, is when you have individuals who are out on a leave of absence like this, that you issue written notice to the employee at the beginning of the right to the leave of absence and state specifically the date upon which it's going to the leave is going to terminate. So there's no, I've had situations where the employee then says, when this pre-termination notice comes up, they say, I had no idea I was limited to a year. And I don't think that really matters, but why give that opportunity to give any explanation here? Just issue that notice at the outset. Here's your leave of absence. Maybe there's going to be an FMLA overlay as well. And so all of it is going to be consistent that, this person knows how long the leave is going to apply. And that, for example, FMLA is going to run concurrently as well. So, just make sure you've got, I think it's a best practice to try to have that at the outset. And as I mentioned, you have the right to immediately terminate an individual who's become permanently disabled. Again, you're going to need solid medical evidence upon which to conclude that. That might come from the employee's provider. Very rare. As I said before, I've not had this circumstance previously.
And just on the FMLA, I know we had that slide earlier about, you mentioned, Colin, running the leave concurrently, which is always a good practice. There was that one case earlier on slide 11 where the court didn't extend the 1-year period to go to 15 months. However, the thing to keep in mind there, that was a New York court decision where the employee wasn't notified of their right to take FMLA leave. Had it been filed in federal court, we might have ended up with a different decision. So always a good practice, as Colin said, to run that time together and to give that paperwork at the outset.
Right. Okay, next slide, please, Kathy. Okay, so again, the employer rights, the right to choose. So this is important. Again, the medical examiner is going to be selected by the county or by the Civil Service Commission. However, in my experience, there's been quite a bit of interplay between the municipal employer, let's say it's a village, and the county Civil Service Commission to say, we need someone with this expertise, right? So it's the village, it's the local employer that knows the most about the disability and why it occurred and why it's occurring. And so I have, very often counseled the village or whatever to work closely with the county on selecting the right medical examiner for the particular individual, because some may be very clear, like an orthopedic injury or something, but very often it's an interplay of multiple types of disabilities, and you may need someone with expertise in multiple areas or multiple medical examiners in order to finally reach that decision. Again, remember, no duty to create the vacancy if you can establish that the workload doesn't warrant filling of a vacancy. Also, you don't have to fill that as well. Next slide. All right, so this slide is just a good one to keep, in your folder on section 71 and 73. Gives you a quick little sheet on what the rights are of the employees, what the rights are for employers as you go through this process. Okay, next slide. All right, so as we mentioned at the beginning, we're seeing more and more, I think, work in this area, litigation in this area, at 71 or 73 area rights. So I think it's something to keep an eye on. One of the bigger developments was at the Court of Appeals in 2022, when in the city of Long Beach, the Court of Appeals held that employers must, upon demand, collectively bargain over the procedures that might apply for terminating a municipal employee in this process. So in my experience, okay, it's very unusual for the employer to actually have that internal policy document I talked about that I think would be a good practice. Very often, it's a situation where you get a call and it's just a report of somebody who's been out, and then you work through the issue. Well, now, after this Long Beach case, we're going to see, and Allison will get into a little more detail in another case that's currently being litigated. We have to negotiate with unions if they want to negotiate the procedures that are going to apply over Section 71, occupational leaves of absences and the termination process that's going to be in play. I think this was not, a huge surprise to a lot of people, but was litigated all the way to the Court of Appeals. And so at this point, I think it's important that you be prepared if you're getting ready for negotiations with the public sector union, that you are likely to see a procedure proposal with regard to Section 71. Now, this case only applied to 71. As we said, there's a lot of overlap between 71 and 73. But, right now, I think you want to, if you get a procedure with regard to 73, which is probably unlikely because 71 is the one that most people are worried about from a union perspective. But if you get something under 73, it's not automatic that you need to negotiate this. So again, 71, if you get a procedure proposal, you're probably going to have to sit down and talk about that. Again, you don't have to do it mid-contract unless the contract provides that you can do that. But if you're getting ready for negotiations, I think you want to start thinking about what is and what wouldn't be acceptable in this area.
Can I just chime in here for a second?
Yeah.
On the mid-contract? So if there's nothing in place right now and you're trying to bargain from scratch, and you're bargaining with a group that's covered by interest arbitration and the Taylor law, what can happen, which can work to your benefit, is that this is the sole topic that goes in front of the arbitrator. as opposed to it being in the mix with other things that are pending with the contract, where you end up with horse trading sometimes, where, employee side, the union gets this, the employer gets that. This would really focus on the procedure. So there can be a strategic advantage to trying to negotiate it separate from the contract.
Yeah, I agree. So do you want to talk about Wappinger Falls?
Right. So while Long Beach was going on, the next case is actually a case that I handled that was going to PERB. So prior to this particular case, PERB had case law that said that the procedures for 71 and 73 were negotiable, but none of those decisions got into specific proposals. So as is typical with some of these things, it's really police and fire that drive some of these cases. I don't know, as a result of these cases, whether we're going to start to see some of the other civil service type units come forward and really push to negotiate a procedure. That's meant to be seen. But firefighters and police officers have added protections under General Municipal Law 207A and C, where they get what sometimes is called super workers' compensation when they're injured on the job. So it's much more valuable to them to hang on to that. That's a whole other discussion about what happens when someone is terminated and they have those benefits. But let me talk a bit about some of the proposals that were in Wappingers Falls. And as Colin indicated, this is currently on appeal from the PERB board's decision. It's now in the court system, and I have a feeling it's going to go all the way up to the Court of Appeals, because these are major issues from both sides. So this first proposal actually isn't really about 71 and 73, so to speak, but buried in here, it says that officers who are on leave pursuant to 71, if they're medically cleared, they have to be permitted to go into a light duty position, and it can exceed up to 3 months. And it talks about how many officers can be in those light duty positions at once. So there's other case law from PERB about minimum staffing, and that minimum staffing is a management decision, meaning that the employer gets to decide how many people are working at a time. And what this proposal does is forces the employer to make that position available for 3 months. And it also says how many people can be in those positions at once. So those are managerial prerogatives. So in that regard, to me, this wasn't a big surprise that PERB would find that this is non-mandatory. And what that means when you're in interest arbitration with a police or fire union, which in this case, that's where this came from, there still is a pending interest arbitration between PBA and Wappingers Falls and the village on this procedure. That's the only thing that's left. That was found to be non-mandatory, and that takes it out of the discussion before the arbitration panel. So this proposal then cannot become part of the actual procedure. The other thing that's in here is that language about that the position is open for 3 months. There is a case from the Court of Appeals that precedes Long Beach called Economico that said it's public policy in New York that you can't infringe upon an employer's right to separate an employee who has met the criteria. In that case, it was Civil Service Law Section 73. And there are 2 issues, and only 2 issues in the statute. Have you been absent for the requisite period of time? And was it because of an injury? For 73, non-work related. As Colin had indicated, these statutes are kind of read together the similar way of 207A and 207C. So I think we are going to get a decision out of Wappingers Falls when it gets up to the courts that these cases, even if it's only on 73, it should be read as also applicable to 71, so long as it's talking about the same public policy. So when you have language in this proposal that says, even if you have, the way this gets implemented is you could have someone who's been absent for the 12-month period, and all of a sudden they get 3 more months. And that Economico says that's public policy. Once you hit that 12-month mark, whether it be cumulative or consecutive, you're out. So let's go to the next slide and talk about.
Allison, can I just jump in?
Sorry, go ahead.
One thing on that slide. Can you go back, Kathy? I think it's just worth mentioning, what does it mean when it's non-mandatory? So, and this is why I think it's really important that if you get 71 proposals in bargaining, you have your attorney look at it, because what you'll hear from the union side is, yeah, maybe non-mandatory, but you can agree to it. Okay. And that is the dangerous move, right? Because if it's non-mandatory, employers retain the right to implement as we see fit, consistent with the statutory provisions. So just because it's non-mandatory, don't let a union talk you into saying, okay, yeah, well, we'll engage on this point. The better move, I think, would be to just not agree to discuss it.
Completely agree, because once you do agree on it, it becomes mandatory, and now you have to bargain against your initial rights to get it out of the procedure.
Yep.
Okay, so the next slide, these are also proposals that relate to the duration of the leave of absence and and staffing issues. So this first one is beyond the statute's scope. That I'm trying to look where we are here. Oh, so this is when you're talking about, so the 71 and 73, they're discretionary, meaning that they don't require an employer to terminate. They give an employer the right to terminate. And as I said before on the last slide, it's 2 issues and 2 issues of loan. How long have you been out and why? So what this proposal on the first bullet point was doing is adding in other reasons that the village had to take into account when they were making a termination decision, all of which are beyond the scope of the statute. So for that case, the argument was based on economico, when it says the public policy is an employee who has met that statutory criteria, for an employee who's met that statutory criteria, an employer has the right to terminate, and we can't infringe upon that right. It's actually a prohibited subject of bargaining because it's against public policy. So that means if you were nice and you agreed to put it in your policy or your procedure, it can't be enforced. So obviously you don't want that in the first place. And PERB agreed in this case and said it was a prohibited subject of bargaining, which was great news for employers. Also, they said the same thing with extending that leave of absence beyond that 365 or 12-month period, depending on how you're counting it. That in this case, when you're talking about that notice that Colin had mentioned about, hey, we're gonna terminate you. This other proposal said that as long as you put in a note saying that you could return to full duty within 3 months, the employer had to hold the termination in abeyance. So what that does is turn that 1-year period leave of absence into a de facto 15-month period, because everybody's going to be saying that they can't come back until that 15-month mark is up. So again, that's extending it beyond the scope of the statute, and that was also found to be prohibited. Okay, then the next one. So the one part of this case that went against the village was arbitration, that they wanted someone, the PBA had proposed that an arbitrator make the decision, but the way they proposed it was that the arbitrator the employees, you couldn't terminate the employee while that arbitration hearing was pending. And the argument here was, again, now we're extending that 1-year period beyond what the statute said. We all know how fast arbitration is, not very fast. And you can put all the expedited language into the contract that you can come up with. It's not going to make it move any faster. So this was knocked out because it was holding that termination decision in abeyance. So what that means is you could have a situation where you terminate first, and then you have an arbitrator potentially have you put someone back, which is kind of a bit of a nightmare. But I'm not so sure that an arbitrator can necessarily force you to open up a position or create a position. So it's going to be interesting to see how that plays out when it's actually put into place, if it is put into place in someone's procedure. But this was also knocked out as prohibited. So we introduced this at first, that this is now on appeal. So it's in Supreme Court of Albany. It'll be probably a few years as it works its way through the court system. And we do expect it to go all the way up to the Court of Appeals. So I think our last topic is just to give everyone some strategies and some concepts to think about when you're implementing these types of procedures. I do see a couple questions, so I'm going to just see what those are. So the sites for the cases, sure, we can get those to you, and the notification letter, we could do that as well. Just shoot us both emails. Our information is on the slide, and we can walk you through the process. So strategies. I think Colin named the first one, which was the paperwork and the paper trail. I also come from the school of thought of letting employees know. I usually say roughly 30 days into their injury or their illness that, hey, you're on a 71 or 73 leave. We're exercising our right to put you on that leave, and to let them know when it's going to end. Identifying the illness or injury that's at issue. That is crucial for a work-related injury, because that timeline is going to be dependent on the nature of the injury. So someone goes out for a knee injury, and then they're out for a shoulder injury, and then they're out for something else. It might not all run together. And if your paperwork doesn't line up and doesn't say that that's what the leave is for, you may end up with a situation where the clock restarted and there's no overlap, and the employee turns out they weren't actually out for a year, and that's not a good situation to be in. The other thing in the final notice, I should just add, when you wait to send that letter until the employee has been out for a period of time, you also weed out little injuries and illnesses that aren't going to be prolonged. I think most of the time when someone's out for a year, the odds of them being able to come back are pretty slim. But you don't want those, someone was out for the flu for 2 weeks and you're sending that letter right away. That's not what the statute's really intended to be designed for. The other thing is, when you're telling someone that they're going to be terminated, you need to include in that notice everything that you're relying on to make the decision that you're going to terminate. Because if you end up in litigation, you're going to be stuck with that. So if it's attendance records, if it's doctor's notes, I would be as specific as you can be to show them that this is everything we've relied upon. And again, it's just the two issues: how long you've been out and why. And I think that's one of the most important things, that make sure you document everything.
Yeah, I completely agree. On one other piece I just wanted to mention is the interplay between GML 207A and C and 71. So if you've got police and fire employees, right, they're still subject to the 71 one-year termination provision for a workplace or an occupational injury. However, you got to balance your right to terminate that individual against the rights and procedures that are set forth in 207. So although some employers may be eager to terminate that employee, that firefighter, for example, who's been out in excess of a year, when you do so, you lose some of your ability to order that firefighter to do certain things. So for example, if that individual is no longer an employee, then your right to order that person back to light duty is gone. Now that may be fine. That may be something that you're comfortable with, but you just have to understand there are ramifications from going through a 71 process with police and fire, where they're also on that 207, 207A or 207C leave. And it's very important, I think, that you get adequate legal counsel as you're working through those issues before you make that decision.
And then when you do terminate and they're on 207A or C, termination of employment doesn't mean termination of those benefits. There are set reasons in those two statutes when the benefits get cut off. What can work to your advantage if you do terminate someone, there could be things in the contract that they're no longer entitled to because they're not an employee. Sometimes health insurance is part of that. However, when you have someone on A or C, you end up having to pay for their medical expenses. So without insurance, it could be really costly, but that is a strategic advantage. I think one thing that employers are doing when they're trying to separate someone pursuant to 71 is they're really trying to force that person to retire, get them off of 207A and C, and then that frees up their position and they can have someone back that actually can perform the functions of the job. So that's important to do. And there are cases too that, as Colin was saying, that just because someone is on 207A or C doesn't mean they're insulated from any action. There's two cases out of the town of Southold where there were disciplinary charges filed on the basis of incompetency for people who had two officers who had been out on extended leave, and they were both on 207C. In that case, the town didn't have a 71 procedure. So their only option was to go for 75. Otherwise, they could end up with, in litigation over having a 71 procedure. And what the decision said was, you can go ahead and terminate someone. There's no insulated protection guarantee to employment. There's just a guarantee to those benefits if someone is terminated.
So I don't have anything else at this point. Allison, I don't know if you do. I think we've answered
the only thing I think we didn't say in the beginning is that on its face, 71 and 73, there's no requirement that you pay people while they're out. They don't stay on payroll. But if there's any leave time that they're entitled to, so sick leave is the one that typically comes up, someone could stay on sick leave. and continue to be on the payroll, but you otherwise don't have to continue them on. And if they're off the payroll, that could also cut off their right to continue their health insurance, subject to any requirement, like an FMLA type requirement.
Yeah, good point.
So I guess we could take a minute to see, there's our email addresses. So for the individuals with the questions about citations and samples, feel free to reach out to us if anyone else has questions. Or as I like to say, if you didn't realize you had one until an hour from now, you can get in touch with us and we'll be happy to answer them.
Yeah.
Kathy, you want to wrap us up?
Anything
Yeah,
else?
I just want to thank everybody for joining us today. A quick reminder to fill out our brief survey. And we hope to see you on the first Thursday in July, which I believe is July 7th. So thank you both, Colin and Allison, and I hope everyone has a wonderful afternoon.
Thank you.
Thank you.